Well, I'm delighted to be joined once again by Lady Dorrian, who has agreed to speak with us with regards to the sentencing guidelines. Good afternoon, Lady Dorrian.
Hello, Edith, how are you?
I'm very well, thank you.
Congratulations again on your achievement of
Thank
the
you very much.
presidency.
Thank you very much. I had a great day yesterday, so
Good, good.
yeah, thank you. So we're really grateful to you for agreeing to come to get on to Hey Legal again and just speak to us about these latest
Yeah,
sentencing guidelines. So I've got one or two questions for you that we might just run through. So just to start off,
yeah.
can you tell us about sentencing guidelines and why you selected this topic for the guidelines you're currently consulting on?
Well, sexual offences take up a huge amount of the work of the High Court, as you know. They're very serious and important cases, and they cover a vast range of circumstances, a massive variation of circumstances from one case to another. And they're, of course, they're of considerable importance to the public. And that's always going to be a factor for us in determining whether we should be preparing a guideline. Are there complications in the way the cases are presented sometimes, the way they're understood? Can we assist with that? Would a guideline help? In this case, we believe that a guideline will bring benefits to the courts. It will assist with clarity for the public, and it will enable people fully to understand the sentencing decisions that are made in these cases by identifying the way in which the sentencing is approached. It will help the public to understand the factors that are taken into account and which are not taken into account, and to understand how these often very difficult decisions are reached. And in addition, we think it should, by the mere existence of the guideline, assist in promoting consistency and predictability in sentencing of these cases.
Thank you very much for that. That helps to explain certainly the thinking behind it. I wonder if you might just explain. Obviously, you've spoken about the public and how important they are, but you've also included a public consultation in these guidelines. So, can you explain why public consultation on such guidelines actually takes place?
Yeah, this is something which is really important for us. We decided really very early on that all our guidelines would be the subject of a full public consultation. One of the roles of the Sentencing Council is to promote the public understanding of sentencing. And in order to make sure that we do that, we need to know what the public are taking out of our guidelines, what their understanding and what their views are. And we do that in a variety of ways. We don't just do it by the means of these consultations. We do it in other ways. We've had surveys about public perceptions of sentencing, and that gives us some good information about what the public think the general level of sentence should be in cases, and whether by giving scenarios and asking the public to be the judge, as it were, we can see the extent to which what they would come up with matches or doesn't match what we would anticipate a court would give. The consultation is a very precise, focused way of involving the public, and there are a number of issues here that we really want to hear people's views on. For example, one of them is a question about remorse. Remorse is a general factor that gets taken into account in sentencing if it's genuine. Sometimes that can be difficult to identify. But our public perceptions have suggested that in some cases, and these cases may be an example, the public are less happy to suggest that remorse should actually be mitigatory. And we need to get a bit more understanding of that. That's just one example. There are lots of others in which we're asking for the views of the public. And it's really important to us that we get responses, because we do sometimes change the guideline as a consequence of what the public tell us. We did that in the death by driving guideline, as I'm sure you know.
Yeah, and I imagine it can be highly emotive, but clearly the public input is shaping and informing yourselves as to what's expected. And I imagine there's a full range of emotions expressed, but I can see how that can really help with the job in hand as to how to pitch things.
The things we look at is the extent to which the response suggests an understanding of the process already, or whether what is being suggested is something that is way out of kilter or beyond what we can do. You know, people don't always understand the basis of what we can and can't do. And we found that in the death by driving guideline. Again, a very emotive subject, as you've alluded to. And we've had that, also we had it with the young persons guideline, where, for example, people misunderstood what we were talking about and thought we were dealing with the age of criminal responsibility, which we were not. Or where people thought we could do something about sentencing that was beyond our power. And we do look at that when we get suggestions from the public to see how grounded it is in reality, and try that way to remove the subjective element from it.
Yeah, absolutely. So that deals with the public side of things.
Yeah.
What role would you like the legal profession to take in the consultation process?
Well, you know, the legal profession play a vital part in this, because it's the legal profession who are going to have to be addressing the guidelines, presenting the material and information to the court that they think is going to have an effect on the sentence, and assist the court in applying the guidelines. And it's really important, therefore, that the guidelines provide a practical guide and assistance to members of the profession. It would be pointless for us simply to produce guidelines that were, you know, airy-fairy and were not rooted in the practical considerations of everyday sentencing. What we have done is we have listed, we've set out how we think that the general approach of the sentence is followed, and that is, I think, going to be universally accepted, that it's to do with assessing culpability and harm. But there are other factors, such as the mitigating factors, the aggravating factors, and the weight to be given to those. And we have tried to capture what we think are the primary mitigating or aggravating factors, but we could have missed some. And there are others that members of the profession might think are important. Either way, aggravating or mitigating. And it's really important to us that we get responses from members of the profession, because they're the ones who are going to be at the sharp end of dealing with these when they're in operation.
Yeah, absolutely. So there are two guidelines in relation to rape offences currently out for public consultation.
Yeah.
Can you explain, please, what they are and why there are these separate guidelines?
Well, there are two draft guidelines, and that's because we're dealing with two separate offences. So the first guideline relates to Section 1 rape under the Sexual Offences Scotland Act 2009, and also the common law offence of rape, because of course we're still dealing with these in historic cases. The second guideline relates to Section 18 of the 2009 Act and the equivalent common law offence, which is essentially the rape of a young child, which under the legislation is a child aged 12 or under. Now, these are separate offences, and separate considerations apply to the sentencing for obvious reasons. So for that reason, we've drafted two separate sets of guidelines. They both, of course, address the questions of culpability and harm, which the court has to consider. They both cover sentencing ranges for each offence, slightly differently, and a non-exhaustive list of aggravating and mitigating factors. You know, I mentioned earlier that we thought we'd captured the main aggravating and mitigating factors. We recognise that it's impossible in the variety of these kind of offences to identify every single factor that might in any individual case be viewed as aggravating and mitigating. So there will be ones which may apply in individual cases that aren't listed, but we would expect them to be taken into account nevertheless because they'll be identified by the court. What we're looking at here really are the main ones, and that's why the list is non-exhaustive. But that's why we have two separate guidelines.
All right, thank you for that. And I guess as these guidelines that we've seen developing, there are going to be situations where different guidelines are going to be involved in the same case. So, yeah. Just thinking about the young persons guidelines, how would these current guidelines that you're looking at, how would they apply when, for example, someone that's convicted is under the age of 25? Yeah,
well, obviously, these offence guidelines, and it's the same with the death by driving guideline, they have to be read alongside the other general guidelines. So they have to be read alongside the principles and purposes guideline, which I'm sure people now more or less have by heart, and the sentencing process guideline ditto, and where it applies, the sentencing of young people guideline. So where the person convicted is aged 24 or under, then the court will have to have regard to both the rape guideline and the sentencing young people guideline, as well as the principles, purposes, and process guidelines. The exact way in which the two interact will be a matter for the individual judge in individual cases. The extent to which the youth of a person is a factor in the offending behaviour and impinges on culpability will vary from case to case. Obviously, individuals are individual, and it will be something that varies according to not just the age of the person, but their maturity, as we've been, I think, really at pains to point out, that the issue is not age alone. It's a question of trying to assess the maturity as well as one can be, because there are factors such as risk-taking behaviour, failure to appreciate consequences, lack of understanding of the consequences of actions, and so on, which apply. And also, there is a question of rehabilitation, which is a primary consideration when sentencing young people, and which our public consultation in relation to sentencing of young people showed that by and large the public agree with the notion that young people should, where possible, be the subject of attempts at rehabilitation. So there will be an interaction. Exactly how it works will be difficult to say. And you know, we did point out in the sentencing young people guideline that some sentences will have a greater impact on a young person than they would have on an older person, and that's something too that requires to be taken into account.
Absolutely. All right, thank you for that. The consultation period is open until the 18th of October of this year. Mm-hmm. So, Dara, what is the process then beyond that?
Well, that gives us, it's about a 12-week consultation process. What happens after that is that we will then consider all of the responses we get, whether from the profession or from members of the public or from organisations. They will be independently analysed for us, trying to bring out what the key themes are and what conclusions could be taken from them. Also helping to identify what conclusions shouldn't be taken, going back to the point I was making at the beginning about potential misunderstandings. And that will help us focus on the things that we should change, or address whether we should change things, and look at that in more detail. So once all of that's done and the analysis is done, the council will meet and we will consider in more detail whether we want to make changes, what those changes are, and why. After we've done that, we'll publish the independent analysis that was done for us, and we will also publish our response to the consultation submissions. Again, we always do that because we want people to understand this. For us, this is not a cosmetic exercise. We really do take account of what people say to us, and we look very carefully at whether we should change the guidelines, the drafts, as a consequence. And sometimes we do, sometimes we don't. But if we decide not to make a change, we want to make sure that we explain to people why we have decided not to make the change, what has motivated us to reject the submission, and just generally give a full explanation of that. Once that's done, we will finalise the guideline, and then of course we submit them to the High Court for its consideration and hopefully approval, because the guideline only takes effect once it's been approved by the High Court.
Right. So, you know, we've discussed the guidelines on a number of occasions. So can you tell us a little more about what other guidelines are currently being developed?
Well, we're reasonably far on with developing a guideline on indecent images of children, another very important area that can be quite difficult actually, and I think people do find it quite difficult sometimes. And so these are the first of a series on sexual offences. So we then will have the indecent images of children. We're also looking at sexual assault, because again, there are proliferation of these cases. They're massively varied. They are very important. They often occur alongside other sexual offences. And so we're developing guidelines in relation to those. We're also working on guidelines on domestic abuse. That guideline will probably be another general guideline along the lines of the young persons process and so on, because the vast range of offences that are encompassed within domestic abuse cases and aggravations would make it very difficult, I think, to do an offence-based guideline. So we're looking to do a principle-based guideline on that, identifying what effect the fact that the offences occur in the context of domestic abuse, either ongoing or historic or over a long period of time, may have on the sentencing process. So work's begun on that. Another area that we're working on and that we hope to be able to consult on in the not too distant future is in relation to sentencing for guilty pleas. That's an area which is reasonably well understood by the profession and judges and sheriffs, although we still get cases where things have gone wrong somewhere, where there's been a misunderstanding. I think there was one this week. But the public, I think, find those much harder to understand. And I think we really have a job here to do to help explain that, but also to set out very clearly how the issue of what the profession refer to as discounting, but the public do not like to refer to as discounting, how that works, sentencing for a guilty plea and recognition of the benefit to society and to the system of someone pleading guilty. The issue of environmental and wildlife crime, which we had suggested looking at earlier has come back onto our agenda. We are looking at these again. They are increasingly of importance and likely to be increasing numbers of cases. So we think that they're ripe for looking at developing a guideline. We have, over a number of years, we've looked at the question of whether we could do a guideline relating to mental health and mental disorders. It's a very, very difficult area to do a guideline on, but we have been doing a series of seminars and conferences with a view to helping us to understand really all the issues that are involved, with a view to considering whether there is any prospect that we could realistically come up with a guideline. It's really important for us that if we proceed with a guideline, we're not just doing window dressing. So if we were to do one for mental health issues, we would really want one that would have an effect, would have an impact, not just be, you know, there for the sake of it. So it's a very difficult area, but we are looking at it in detail. Otherwise, I think we've got more detail in our business plan, which sets out our work programme for the future. And we're always open to hearing suggestions from people about areas where they feel that a guideline would be welcome.
Well, lots to keep you busy by the sounds of it. And you've emphasised the importance of input. So we'll certainly be promoting or encouraging people to realise that the window will be here before, you know, we close before we know it's the 8th. And clearly you want to encourage as many people as possible.
Absolutely. It's really important to us that we get members of the profession responding and, you know, taking time to think through the questions that we've asked and reflecting maybe on cases that they've been involved with and what they think the outcome should be, shouldn't be, what should be mitigatory, what should be aggravating, and so on.
Well, thank you so much for your time, Lady Dorrian. That's been really interesting, and I'm sure, I hope that will prompt some responses from the profession, if not other members of the public as well. So thank you so much.
Yeah. Okay. Thank you very much, Edith. Okay. Bye-bye.